Christina Kakaflikas, and I'm the Acting Director of Markham's Department of Economic Growth, Culture, and Entrepreneurship, which includes the Markham Small Business Center. The City of Markham is proud to collaborate with Minken Employment Lawyers this morning as part of our series in partnering with the private sector to deliver subject matter expertise on the important next steps to economic recovery. This webinar is the third of a series of virtual gatherings hosted by the City of Markham in partnership with the private sector aimed at economic recovery. The series is meant to support our business and investor community, build economic resilience, and chart a new path to sustainable growth. As I said, the Markham Small Business Center, which is led by Don De Los Santos and Tiffany Mack, with a special support by Leah Baird, who's on the line as well today. The Small Business Center provides business advisory services, webinars, seminars in support of small business and entrepreneurs. And we'll have more information about the MSBC as well as where to go for information on the latest updates on COVID support. Of course, the MSBC has partnered with Minken Employment Lawyers previously, and we've been working with MEL for many years now. And they're known, MEL is known as leaders in their field of employment law. Minken Employment Lawyers are known to help businesses not only in Markham, but throughout the country with workplace legal issues. We are pleased that they're also located in Markham, of course. I understand that Minken Employment Lawyers are celebrating their 30th anniversary this year, so a special congratulations on the success of the firm and all the best to you moving forward. Given the mental health impact that returning to work will have, we are excited that they have also been focusing on mental health issues. I understand Minken Employment Lawyers has many guides related to hiring, termination, sick leave, and return to work. And all of these guides can be accessed from their website and a monthly newsletter that contains important legal information. From Minken Employment Lawyers, we have employment lawyer Aneesha Lewis, who will be moderating. We also have the founder and managing lawyer, Ron Minken. He has practiced employment law for 30 years, published extensively, and is a sought-after speaker. Their special guest today is psychologist Dr. Joseph Garber. Dr. Garber is a well-known leading Canadian psychologist, both in advising patients and also in the legal field. And I understand that our moderator will formally introduce Dr. Garber. Just before we get into the program, I wanted to remind people of some housekeeping items. All participants will be muted and cameras turned off. If you have your camera turned on, please turn it off. This achieves two things. It helps us to preserve bandwidth, and it also keeps the focus on the speakers. This webinar is being recorded and will be available online for future viewing. Please bear with us in case there are any technical issues. I think we've done 3 now. We're getting pretty good at this, but please bear with us if there happens to be any issues along the way. Okay, and I think with that, I will turn it over to Aneesha, our moderator for today. Thank you.
Thank you, and good morning, everyone, and thank you for joining us for our webinar this morning. As mentioned, I'm Aneesha Lewis, and I'm a lawyer at Minken Employment Lawyers, and I'll be your moderator this morning. First of all, we just want to say thank you to the City of Markham and the Markham Small Business Center for organizing and facilitating this webinar, and we're happy to be a part of their Returning to the Workplace series. We also want to say a special thanks to Mayor Scarpitti, who took the time to reach out to us to find out what issues businesses in Markham were experiencing. And as an employment law firm, we end up being at the center of the economic pulse often. So it was nice to be reached out and try to figure out how the businesses can be helped. So again, thank you to everyone attending, and especially on a Tuesday morning after a long weekend. And given the provincial government's announcements last week, and with some more businesses opening their doors today, we understand that many are looking forward to reopening and the rejuvenation of businesses in Ontario. So we are really excited about providing this webinar for you this morning. We've seen some separate webinars dealing with employment law and reopening and less dealing with mental health aspects, but there's a few out there, and we really wanted to bring them together. And it's critical that these two topics are actually thought of as sort of the same part of a related coin. And so this webinar is a great opportunity to get to hear the opinion of professionals in both areas and how they relate. And it's our belief that before any employees return to work, employment law and mental health must be considered. So the format of the webinar this morning will basically be done in two parts. The first one, we have prepared some topics which our speakers will address. And second, we received the questions you submitted in advance, so we will then have the speakers address your questions, and hopefully we're able to get to all of them. And we have a special guest with us today, and I will introduce Dr. Garber now. So Dr. Joe Garber is a clinical rehabilitation and forensic psychologist. He has been providing clinical treatment as well as preparing socio-legal opinions regarding the psychological functioning in matters of personal injury, medical malpractice, and employment law for over 30 years. He has also been qualified as an expert by the Ontario Superior Court of Justice. He obtained his master's degree from McGill University and doctorate from the University of Toronto. He has a certification in medical legal expertise from the Canadian Society of Medical Evaluators and the Canadian Academy of Psychologists in Disability Assessment. So, in other words, he knows his stuff, and we're very happy to have him with us today. So we have our own little set of housekeeping to do before we really get into it. And we would not be lawyers if we didn't tell you this. And the content of the webinar is not and should not be construed as offering any form of legal or psychological advice. So no steps should be taken or not taken based on what you hear today, as every case and clinical circumstance is different. So we recommend, strongly recommend, speaking to a professional should any of the situations discussed actually occur. Also just wanted to mention that some of the situations we discussed today may have a different process if your company falls under WSIB, as WSIB has its own set processes for workplace injuries. And WSIB is a category unto itself and really could deserve its own presentation. So in order to ensure we're able to address the most content today, we will not be discussing WSIB processes or taking questions on WSIB. However, if you do have questions, please feel free to reach out afterwards. Also, just to mention that the discussions today may or may not apply to unionized environments. So let's get started with the webinar, the new workplace, employment law, and mental health. So before we jump right in, I think it's important to deal with some employment law basics. So Ron, can you briefly describe what is a standard procedure and expectations for bringing employees back to work? And spoiler alert, folks, we're not discussing reductions in staff now, but we will later on.
Great. Well, thank you, Aneesha, and welcome everyone to this webinar. The return to work. So at this point, many have been are going to be returning from a layoff. And this is considered a temporary layoff under the Employment Standards Act. So how to get them back? Well, reasonable notice of the return, ideally in writing. And the only requirement under the Employment Standards Act is that the employee return within a reasonable time, given the circumstances. So you want to keep in mind the deadlines. There's two temporary layoffs that one can affect under the Employment Standards Act. One is for 13 weeks long and the other is 35 weeks long. The latter one is when different circumstances, for different circumstances. So if you recall, or if an employer recalls within one of those, then the employment relationship continues and the employees essentially have no further entitlement. They're working, they're now getting paid. So that's if you recall within. But what if you don't recall within, you happen to miss a deadline? Well, in that case, it's deemed to be a termination, and then termination notice is owed, and that can be substantial. So if you then rehire, that's a new relationship. And in that case, it would be, you'd be then limited to common law notice Now, if you have an employment contract or hiring letter, then you're able to have it, the notice being an amount less than common law. So if there's a new relationship, there's no agreement, then common law notice applies. If you have an employment contract that the employee signs prior to starting, or hiring letter, and there is a termination clause that limits the notice from common law, that's when the employer can save on that. Now, in some cases, there could be a recall notice. And what cases could those be? Well, it may be set out in an employment agreement, and if so, or a hiring letter, let's say, or a collective agreement or a policy. And in that case, the employer must follow the recall procedure if it provides for a greater right or benefit to the employee. Now, what if you're returning from working from home? Well, really, the employer requests that return. There's really no set of rules for that. Reasonable notice of return should be given, though, ideally in writing. The length of notice, what should that be? Well, it depends on the circumstances. It could be a few days or it could be longer. Now, what's there to keep in mind? Well, some employees may not be able to come back immediately. And why is that? Childcare obligations, or perhaps caring for a family member for COVID-related issues. Now, under the Employment Standards Act, the employee may still be able to take a leave under the new emergency leave provision. And it's actually called emergency leave, declared emergencies and infectious disease emergencies. That's a mouthful. But if you want to Google it, you can just put emergency leave, declared emergencies, and you'll find that. So now what does this say? Well, under this leave, employees that are providing care or support to an individual because of a matter related to COVID-19 that concerns that individual, including but not limited to school or daycare closures, are entitled to unpaid leave. And this leave can last either until they no longer need the leave for the children or family members due to COVID-19 reasons, or COVID-19 is no longer considered an infectious disease under the regulations. Now, what you got to remember for all employers is the Occupational Health and Safety Act. Applicable now, before, post-COVID, and at any time. The employer must always provide a safe workplace. So what does the employer have to do? Well, take every precaution reasonable in the circumstances for the protection of the worker. So what could that mean? Could mean PPEs, protective personal equipment. It could also mean configuration of the workplace, including the number of people per square foot or square meter. It could mean temperature testing, a whole bunch of things. Ontario and other entities developed safety guidelines for different sectors. And this is very good, very extensive. And these are from the Ministry of Health or Health and Safety Associations. And there's four that I saw on the website. One is the Infrastructure, Health and Safety Association. Number two, the Public Service Health and Safety Association. Number three, the Workplace Safety North. And number four, the Workplace Safety and Prevention Services. They're all on the Ministry and Government of Ontario websites. So what is it critical to consider? Well, mental health issues. Many webinars that I've seen on mental health, they don't consider that along with the employment laws in a return to work plan. Now, after we've worked with about 10,000 clients over 30 years, and including representing law firms across GTA, and also practicing through SARS, that was 2002 to 2004, we believe that it is critical to consider these mental health issues. Now, a legal return to work without considering mental health may also be negligent and may also be a breach of the Occupational Health and Safety Act. So we thank that everyone's here today and that we're here also. Our special guest that we'll be listening to is to speak on mental health in the return to work is Dr. Garber. We're glad that we're present to listen to him and that he's joined us today. Now, a bit of background how we met. For a case we needed to find out the best psychologists in the country who could write the best report and give the best witness evidence in court. So one of my colleagues, John Burns, he did some research having cross-examined, I think, likely over 100 experts across the world and suggested Dr. Joseph Garber. So we've been working with Dr. Garber, and coincidentally, at the same time, we both thought of the same thing, being the importance of collaborating on getting the word out about combining mental health considerations in a return to work plan. So, ladies and gentlemen, we are privileged to have Dr. Joseph Garber, attend to help us today.
Thanks, Ron. And then I guess I better ask Dr. Garber a question. So Dr. Garber, in your opinion, is there sufficient attention being placed on the mental health component of this return to work?
Let me first begin by thanking Ron for your kind comments. My experience has been that the value of an expert can only be determined after they've completed the work for you. So let's see what you think after I've done what I need to complete. I want to thank Minken Employment Lawyers for inviting me to participate in today's webinar. The mental health associated with the COVID-19 pandemic is only beginning to be recognized. Regardless of how optimistic we want to be, I believe that we are very much in the beginning phases of this pandemic and its return. As a result, primary issues involving life and death will always take precedence. Therefore, the enormity of the mental health concern will only come to light when life and death matters have been more stabilized. I think we all appreciate that this is an ever-changing process, and therefore anything that is suggested today may or may not apply tomorrow or the day after. We can, however, reasonably and I think accurately assume that there will be a notable mental health degree of reactivity. It's not inconsequential that the federal government has recently allotted millions of dollars for additional mental health services. It's also not insignificant to recognize that amongst the first order of business openings today include in-person counseling. We don't need to look very far to acknowledge that stress, anxiety, and depression has had and will continue to have a direct impact on how we come back from this. Some are suggesting that what we are about to enter into can be referred to as an echo pandemic. In other words, the psychological impact that this pandemic will have cannot be fully and accurately anticipated, but will in fact mirror the extent and intensity of the difficulties we're already experiencing. On May 16, 2020, 3 days ago, the British Medical Journal published an article entitled "COVID-19, Mental Health Services Must Be Boosted to Deal with the Tsunami of Cases After Lockdown." This is a leading-edge European medical journal that publishes this article just recently. Preliminary research suggests that the rate of depression has doubled and the rate of anxiety has quadrupled as a result of this pandemic. The Director General of the WHO recently said that the effects of the pandemic on people's mental health was extremely worrying. Specifically, he mentioned that social isolation, fear of contagion, and loss of family members is compounded by the distress caused by loss of income and loss of employment. He went on to say that a failure to take people's emotional well-being seriously will lead to long-term social and economic costs to society. We truly live in unprecedented times. While we have a reasonable understanding of the impact that trauma can have on individuals, we never before have needed to contend with the type of traumatic societal event that is currently in operation. We often hear that we're all in this together, and a recent article suggested that while we are all in this together, we're navigating these rough waters in different ways. Some of us have had easier times of it, while others have been challenged with numerous life issues, working on a full-time basis remotely, being a parent, a teacher, a partner. All of that has, in large part, contributed to the extent of continued pressure and distress. It seems to me that what we need to keep in mind is that we are not talking about a disaster that has befallen us and has ended. We're still very much in the active phase of this dramatic process. There's much that will come, and with each step along this process will come uncertainty, confusion, risk, and a lack of clarity, which will all result in some form of psychological reactivity. We're all afraid to varying degrees and intensities for ourselves and our families and our loved ones and our community. And we need to recognize that there are stages along this process. In this regard, we share a common destiny. We're only starting to attempt to leave our homes. We probably also well appreciate that everything that we do today will likely need to be modified at least to some degree in the near future. We're here today to try to better understand and manage the mental health related concerns in your place of employment. Just as we acknowledge the frontline workers whose courage and commitment cannot be underestimated, I also want to acknowledge you as employers. Were it not enough that you have to look after your own needs and the needs of your family, were it not enough that the majority of you are probably challenged with significant economic difficulty and uncertainty, you also now have to deal with managing your employees who bring their own challenges to your place of employment. You understand that this is not simply unlocking the door and letting everyone in. I think we all need to be cognizant of the fact that there are ever-changing flux, that we are in an ever-changing flux, and our best laid plans may or may not need to be changed tomorrow. I believe there are things that can be done to help contain the types of difficulties that we can anticipate. I'm deeply committed to the idea that the most important thing that a leader can do is to remain empathically sensitive and provide truthful, scientifically driven, consistent, accurate, transparent, and authentic information. Develop a reputation of being straightforward and honest with your people. Keep people apprised of circumstances, even when circumstances are changing. Let them know that they can trust you to give them the most up-to-date and accurate information available at the time. This is important, in my opinion, not only to help your employees deal with the trauma that they've experienced, but will also help manage the uncertainties and ever-changing process that we are likely will be confronted with. If there's one message that I want to send, is that I strongly encourage you to provide clear, genuine, and authentic information to your people so that your employees will be better able to trust you. Many will say that they care about the safety and security of their employees. Those that show that care will fare better in the days to come.
Great. So taking that into account, now that we start talking about returning to work, Dr. Garber, will every employee that returns have mental health adjustment difficulties?
I think it's safe to say that fortunately, no, that is not the case. The vast majority of people that come back to work will be able to come back to work feeling anxious and feeling uncertain to some degree, but being able to manage that uncertainty for a period of time, and then it will progressively diminish. It will eventually fade away. So I think that the vast majority of individuals will make this transition effectively, efficiently, and successfully. However, there are a subset of individuals that will probably have greater difficulty.
Okay. And what would you say would be the typical psychological adjustment process for the majority of people that go back to work?
I wish I could answer the question as clearly as you've posed it. There is no typical. What we can say is for those that are struggling with psychological-based issues, that struggle is very individual and very unique. There are those who have come to this COVID pandemic with a pre-existent history of psychological vulnerabilities. It's those that I think we need to be particularly attentive to and cognizant of, because they are the ones whose experiences will likely intensify with increased stress and pressure. If we think about mental health as a form of an air conditioning system, the effectiveness and efficiency of an air conditioning system is determined by many factors: the actual machinery itself, the circumstances in which the machinery operates, the environment and the demand that is being placed on it. And all of these things form a very delicate balance. Over time, however, every piece of apparatus will find a way to develop difficulties in some fashion. This is not to suggest that everyone's difficulties will necessarily result in a disability, but one's ability to efficiently and effectively manage the stressors that come with one's life experience can become diminished. These types of environmental circumstances, referring to the COVID-19 pandemic and its sequelae, its associated issues, are one of the most significant and most challenged pieces and threat to one's individual sense of stability and safety.
And why do you think this return to work is more challenging than a standard return to work prior to COVID?
I don't know yet. Ask me the question in 6 or 8 months. What I anticipate is this. We are in the process of attempting to find a way to manage, and this process of management will evoke and continue to evoke uncertainty, not just in terms of having people come in to the workplace and stay in the workplace, but what happens to those individuals who are particularly sensitive to issues of safety and security when they hear of a resurgence of cases, which we likely will have at some place, whether it be in Ontario or in Canada or other parts of the world. How are we going to manage the kind of stress that comes with an event that hasn't yet ended? We're of this thing. So that's why I think this is a unique challenge in that we are, in fact, talking about managing a crisis that is in process.
Thank you. So Ron, from an employment law perspective, what can an employer do to ease the employee's return to work? And what are some strategies you may suggest?
So the key thing, Aneesha and all the participants, is the employer needs to ensure a safe workplace for the employees. So how do we do that? Well, develop a COVID-19 return to work plan. Number 1, communicate the plan to the employees. Number 3, post it in the workplace. Also, develop a policy based on the plan. So an employer should keep on reassuring the employees that the physical condition is safe. No doubt, many steps would have been taken to make sure it's safe. So the employee should be notified about that. The employer also want to communicate the steps of what was done to ensure a safe workplace. Someone asked if speaking moistly is sufficient. Well, the answer is no, it's not. Notify employees in writing of all the efforts. Include that in your policy. Things such as physical spacing of workstations, the numbers of employees in the office at any one time. Perhaps you may need additional space or alternate work schedules. Set up procedures if one is ill or they have a family member that is ill for travel, ventilation improvements perhaps. There was a webinar about a week and a half back I heard through the city of Markham as well. And Samantha Sinella from Cushman and Wakefield, she did an excellent webinar on the topic of risk mitigation strategies. And a lot of it had to do with the configurations of workspaces, accessing them, elevator use, etc. And their materials are really good. So you can either go to their site or go to our site. We are going to have that on our site as well, and the materials are excellent. In the next few days, we're going to be publishing a guide on return to work based on this webinar, more so a summary of it. So if anyone is vehemently taking notes, then you can put your pens down, because just go to our website, and in a few days you will see the summary of this as a guide for you. We have some other great guides to help: termination, employment contracts, sick leave, things like that. Also in our newsletter, we've been releasing a lot of information that we've come across, and things seem to change day by day, hour by hour, minute by minute. So we're releasing a lot of information that's critical for any employer to know. These can be legislative updates or court cases or policy statements that are being released. So you can sign up for the newsletter on our website as well. Another idea is display a certificate that your workplace has been professionally cleaned, because that will be a large concern for many people. So that's one thing that can be done. I know a law firm had theirs done downtown. I think they have 15,000 square feet. I think it took them 8 people. It took 3 or 4 days to clean. So I asked the person if he had received the bill yet. He hadn't. But these are other mechanisms that are being done. Very special cleaning, not your typical one. And that's one way to assure the employees that you've done what you are supposed to do to make sure the workplace is safe. Now, is perfection possible? No, it's not. But at least demonstrate that you've done as much as you reasonably can. And if you do the above, most employees will be reasonable, and they'll understand and feel that the employer has made an effort in their return to work plan. And of course, then less likely the employer will challenge it. Now, what if the employee says that it's unsafe? Well, you want to ask them why they feel that way. Try to get the details from them to see whether it's a concern related to what's called a physical condition of the workplace, and that's Section 43B of the Occupational Health and Safety Act. Not to do with how they feel or anxiety or anxiousness or distress issues, but the Occupational Health and Safety Act has to do with the physical condition of the workplace. So that is the analysis, at least at this point. So, can it be remedied? Maybe their concern is valid, maybe it's not. Now, if they challenge it, at least then the employer will have evidence to show to the Ministry of Labor that they've done everything reasonably possible to ensure a safe workplace. So what is the key to employers? Well, to this matter, the key is the employer having evidence to show to the Ministry of Labor that they've done everything reasonably possible to ensure a safe workplace. So the key, mitigating liability and the likelihood of a Ministry of Labor complaint, a lawsuit, or a human rights application. So, conclusion, be understanding. We're in unprecedented times. It's better always to take one extra step if the cost of doing so is low versus spending money responding to a Ministry of Labor complaint or a human rights application or a lawsuit. That's a very good practical tip, I'm sure.
Thank you. So I'm hearing that communication is very important. If you've done a lot of hard work tidying up, reorganizing the office, tell them about it. And so, Dr. Garber, how important would you say it is that employers provide a description of what they have done to make their work environment safe to employees? Oh, you've been muted.
Thank you. I think it's important, not just because it is a significant thing to do in terms of avoiding future difficulties, but I think in some fashion it needs to be recognized as a way of managing the kind of stressors that all individuals will experience to different intensities when contemplating coming back to work. If the workplace establishes itself as being a place that is safe and responsive and attentive and empathically sensitive, meaning it is a place of employment that is interested in knowing how you're doing. You welcome the fact that people respond or provide information about how they are experiencing the work return. Are there things that could be done differently? Establishing and maintaining a dialogue, establishing and maintaining a channel of communication, I think is a simple step that can help avoid future difficulties. And in that process, you can get a sense of how your employee is actually managing. So the first rule of operation is to recognize that turning the key and opening the door requires more. And one of the things that it will require is an opportunity to hear how a person is doing and to give them a chance to listen to what you have to say in an authentic, genuine, transparent, and consistent fashion.
All right. And so before we jump into the portion of the webinar, we're going to be discussing employees that for one reason or another may not be able to return to work or continue to work or just don't want to. I just want to take a moment to clarify the difference between a work refusal under the Occupational Health and Safety Act and an employee who doesn't want to return to work or is it unable to return to work for mental health or other legitimate reasons. So Ron touched on it briefly, but basically under the Occupational Health and Safety Act, an employee has a right to refuse unsafe work. And it outlines a process called a work refusal. And that work refusal is more focused on the physical condition of the workplace. So if they have concerns about equipment or a machine or workplace violence, that's when a work refusal comes into play. And so it's not necessarily about mental health, it's about the physical condition of the workplace. And not every employee can do it. It wouldn't be law if there weren't exceptions. So some employees, like essential workers, frontline responders, healthcare workers, there's a list of ones that can't actually refuse to work, but a lot of employees can. So it's important to keep in mind that this is a process that could occur, not necessarily related to the mental health of an employee though. So there's two stages in a work refusal. The first one is where the employee informs the employer that they have an issue with the workplace, and the employer has an opportunity to respond and try to fix the situation if possible. And it can end there if the employee is satisfied that, you know, whatever their concern was fixed. If not, the second stage is the employee or the employer would report this work refusal to the Ministry of Labor. The Ministry of Labor would send an inspector, and then the inspector does its thing and issues orders if necessary. So that's a very formalized process that's dealing with the physical conditions. So when we're talking about if it comes up with a work refusal or employee refusing to work further on, we're not talking about this process. We're talking about just in general, an employee that does not want to return to work. So just wanted to clarify that before we move any further. So taking that into account, Dr. Garber. So some employees may be eager to return to work. However, once they start, they realize they're unable to continue. What are some red flags that are suggestive of an employee that is struggling with mental health concerns?
I'd like to approach the question by suggesting that there are at least 4 types of employees. The first group involves employees who are eager and thankful for the opportunity of being able to return to work. While they too may be experiencing some degree of anxiety or trepidation, that will likely not be limiting or disabling. Those feelings will gradually diminish and dissipate as they expose themselves and reestablish the work return process that they are very much appreciative of and grateful for. That level of anxiety itself will just by spontaneously resolve. A second group of employees are those that are known to you. They are known to be emotionally fragile, if not vulnerable. They have demonstrated such sensitivities, such emotional sensitivities before, and therefore can be anticipated to respond rather intensely to the COVID pandemic and its sequelae. They likely will tell you how fearful they are of leaving their home, let alone coming back to work. Their risk tolerance is limited. And this is an important realization, an important recognition that for some people, their level of risk tolerance will dictate their level of investment or involvement in the world around them for an extended period of time. Keep in mind that this fear can be associated inside of themselves because of who they are and how effective their own air conditioning system is, in conjunction with the reality of the situation that they find themselves in. They may need some form of accommodation, possibly of continuing to work from home while their colleagues return to work. It's possible for such individuals, they'll have an easier time of coming back once they see that others have been able to successfully return to work without consequence. In addition, one can consider supporting them by encouraging them to pursue treatment, either through OHIP-covered clinicians, a contracted mental health professional, or some type of employment assistance program. That their difficulties are real and in many ways need to be in some fashion managed. Regrettably, there's also a group of employees that will take advantage of this opportunity. I'd like to believe that this is a small proportion of the workforce, but this small proportion of the workforce can take away a substantive degree of those resources which should be available to those who really need it. We'll talk about this in greater detail. However, I think it is sufficient to say at this point in time that you need to be able to identify those who are likely involved in some such activity. Yet again, turn to your consultants, and I'm going to suggest strongly that you find a consultant that will help you navigate this process, whether it be through a mental health or legal perspective. Discuss what options may be available to you in terms of determining what is really going on with a given individual. In my opinion, this will at some appropriate point in time likely require some form of objective and independent examination or assessment. The last group of employees are those that haven't had notable degrees of pre-existing psychological concerns. They see themselves as, if you will, super people who will not allow their sense of fear or trepidation or dread to get the better of them. They would likely consider all of the previously mentioned personal vulnerabilities as a sign of weakness. By the way, it's the same group of people that can also push themselves and proverbially soldier on through what is about to come. But it is with this group that you need to be particularly attentive. Therefore, there needs to be a process where you or those involved in their direct supervision carefully pay attention to a number of very specific issues, such as, do they develop problems with tardiness or absences? Is there some suspicion of substance abuse? And I should mention that in addition to all of the other challenges, substance abuse as well as marital and familial distress will likely become a very prominent area of clinical focus. Watch carefully to see if there is a change in their work behavior. You know these people, you know the quality of work that they've been able to show. Watch and see if in fact there's some change in that process, because that can signal some changes in adapting to the process. If there is a change in productivity, or you've noticed changes that have occurred, I would suggest that you discuss this with the individual. Suggest if they recognize the need for some assistance with their family physician, monitor them, follow them, support them during their process of recovery, and see what happens over time, because these kinds of difficulties don't develop quickly and don't resolve quickly. So at some point, there may be the need for an independent assessment as well.
Okay, so Ron, what is an employer's obligation in this type of situation where an employee is unable to continue with work?
Well, the issue here is whether the inability to continue is due to the physical condition of the workplace. And you've mentioned the Occupational Health and Safety Act. We discussed Section 43B, and that deals with one thing, it's the physical condition of the workplace, and that's the analysis here. So the employer should ask the employee if the physical condition of the workplace is related to it, or is the reason, and then do everything reasonably possible to correct it. So ask the employee, what is your concern? If they say it's a condition of the workplace, see what that is. And if what they're saying is reasonable, then it'd be best to correct it. Now, whether it's a physical condition of the workplace or not, the employee may be suffering from a mental disability protected under the Human Rights Code. The employer may say that they suffer from anxiety, which may be a protected ground, or may say that they are not suffering from any anxiety. The problem, though, is even if the employee says it's a physical condition and doesn't say they suffer from any anxiety, the laws, of course, are favorable to employees and not employers in Canada. A court could say that you should have known that the employee was suffering from anxiety, and failure to accommodate could be a breach of the Human Rights Code. So very, very tricky grounds. The employer has a duty to accommodate. However, they also have a right to inquire as to what accommodation is required and the prognosis. The employer could require the employee to provide a medical note, let's say, with respect to this. Doctors are often advocates for patients, so employers can question medical notes. We often draft letters for our clients to forward to the employee to send to their doctor, asking specific questions regarding required accommodations. Often, accommodation where there is anxiety requires a gradual return to work. We prepared these return to work plans for the doctors in hopes that they will approve, and then the employee will gradually return to work on a full-time basis. Now, an option, of course, at some point would be the independent medical examination or an assessment. And this would be done by a psychologist, hopefully a very, very known psychologist, such as Dr. Garber. Now, as COVID-19 is a worldwide pandemic, the courts will likely recognize more accommodation. And when I say courts, I also mean the Human Rights Tribunal. We have the federal one and also provincial. Also likely recognize more accommodation required than usual. And that mental illness takes forms of being a protected ground under the Human Rights Code. The risk of employer liability in these circumstances during these times is certainly higher than usual. So what is the best practice? Well, if an employee says they're unable to continue and you've ruled out the physical condition of the workplace or cannot reasonably comply with changing the workplace, then try to accommodate them. Accommodate them even if they've not mentioned that it is due to health or disability. The concern is that, while an employee may not have mentioned that the real reason is anxiety, or one of the reasons, a court may say that given the circumstances, you should have known and therefore accommodated. So what does the law expect an employer to do to satisfy their obligation to accommodate under the Human Rights Code? There is no obligation to provide perfect accommodation or accommodation in all circumstances. The employer's obligation to accommodate is up to the point of undue hardship. So if an employer says they're going through hardship, hardship is required under the Human Rights Code, but not undue hardship. The big question then is, what is hardship and what is undue hardship? And of course, this is considered on a case-by-case basis, considering many factors. And as I mentioned earlier, the employees cannot expect accommodation to be perfect. This is where there is a lot of litigation and court decisions over as to what is undue and what is hardship. Now, a form of accommodation could be working remotely. And as a lot of employers have realized that this tends to work fairly well, perhaps that would be a very suitable form of accommodation that the employer would be happy with and the employee as well. Now, if the employee fails to cooperate with reasonable accommodation proposed by the employer, then the employer has to fill their obligation. So that is the law, some good basic principles and guidance on that area, Aneesha.
Great, thank you. And I just want to point out too, Dr. Garber had mentioned substance abuse may become a major thing in the workplace after this, and should be noted that substance abuse also can fall under the disability category under the Human Rights Code and can be a protected ground that would also require accommodation from the employer. So to keep that in mind as well. And now, Ron, so that's an employee that came back and then for whatever reason was, or for anxiety reasons, not able to continue. What are the responsibilities of an employer where an employer says, okay, it's time to come back to work, and an employee says, no, I can't, I'm too anxious, or maybe they provide the employer with a medical note. What's the employer's obligations then?
Okay, excellent question, Aneesha. And this is where it gets tricky, because if the employer says that I don't want to return to work, I don't feel it's safe, then you try to rectify it. You do as much as possible, and you can't have perfection. However, in this case, it's a bit different because the reason's different. Here you've said it's triggered by an employee stating that they are too anxious to return to work. So now it is a bit similar to an employee not being able to continue working. First of all, determine whether the Occupational Health and Safety Act refusal is one of that under that act or not. In other words, does it relate to the physical condition of the workplace? If it can be remedied, great. If it can't, then there are potentially human rights issues requiring the employer to accommodate the employee while on a paid or unpaid medical leave, or STD or LTD if there's a company plan. Now, most comments about being unable to continue to work would apply here. So they say they're too anxious. Well, there may be a reason to accommodate. Now, the key thing is, if that were to happen, you would then require them to produce a medical note. Once they require accommodation, they would not receive it automatically. The employer is within their rights to ask for a medical note. So they get that. And what if it says that, Johnny feels anxiety and can't work? Well, certainly you can get, and most medical notes are actually extraordinarily short. Well, you can require more information on this, such as what the prognosis is, such as whether they can return with accommodation. If the return and accommodation, what sort of accommodation is required, and a whole number of things. So, and also, again, working remotely could be considered a form of accommodation. So the key thing is really working with them, working with their doctor, if the medical note is insufficient, then getting more information, having legal counsel draft proper letters of questions to the employee to provide to the doctor. And at some point, the doctor, even though they're often advocates for the patient, will still want to be accurate in their response. And often just a matter of time that the employee does return to work. And if not, at some point, an assessment could be done as to whether further accommodation is required, and if so, what are the terms? And it could be done by a psychologist. So these are some good methods of how to manage the situation where the employee says they're too anxious to return to work, and involving the medical note and what to say and what to ask.
Thank you. So, Dr. Garber, from your end, what happens when an employee goes to their family physician and tells them that they are afraid or anxious and they can't work? And I think probably the main question an employer might want to know is, how do you know if this type of concern is real?
Excellent question, Aneesha. Much like what Ron suggested, physicians will likely support their patients in whatever is being suggested to them. And for all intents and purposes, I believe that you as employers will also want to support your employees who are struggling. We are very much on the verge of entering uncharted waters. The employment law as it stands seems to be focused primarily on physicality and safety issues from a physical perspective. I think with time, the substantive issues around mental health related issues will filter into that issue of law and to the process of adjudication. But you're right, I think the main event is trying to determine whether an employee in fact is struggling with a legitimate, authentic, genuine difficulty that they need assistance with, or that they are gaming the system. And as I mentioned, I think that employers will do well to develop strategies and processes to help them determine to what extent they need to turn to people like you and Ron, and perhaps psychologists, in order to more clearly understand the nature of the presenting concerns and the course and process of the treatment that the individual is pursuing. These types of things take time to resolve. What becomes particularly important is to recognize that the vast majority of individuals who do struggle with these types of anxiety-based issues can and do recover. It's when they don't recover, or when the issue of limitation and disability persists over an extended period of time, that one needs to raise questions. I think that the two of you would agree that you need to begin by believing what a person is telling you until you have information to suggest otherwise. And I think in some respects, because this is not a fracture, or this is not a physical injury that can be determined as a result of X-ray or MRI or SPECT or PET scan, this is the type of phenomena that is very new to all of us.
Dr. Garber, I have a question
So
for
I think
you.
that in order to satisfy your own concerns, do what you need to do to rule out whether the system is being gamed, and support those who need the assistance that is necessary.
So Dr. Garber, I have a question for you. Given COVID-19, I believe that everyone to some extent has some anxiety in the return. It could be even just because they haven't been at the office for a longer period of time. They've been working out of their home. So anxiety will be common. How do you distinguish the kind of anxiety that would be protected under the Human Rights Code, where the employer must accommodate, and the kind of anxiety that they know they are not required to accommodate?
I need to better understand what the Human Rights Code says about legitimate anxiety that does not require accommodation. I think that from a clinical perspective, issues around compromised functioning, whether it be limitation or disability, is a significant issue. And in terms of the generalizability of levels of anxiety, if I were to ask the participants today, and I think there are over 100 people here, if I were to ask them today if they would be attending this seminar in person, if it was as convenient, how many would think twice about doing that? How many people would be cautious about exposing themselves to risk? So issues of whether anxiety is legitimate, I think is an established fact. Anxiety is legitimate. The question is, to what extent is that anxiety limiting and or disabling? And again, if you are satisfied that the employee presenting with these concerns is known to you, you don't have concerns about them engaging in disingenuous behavior or activity, you don't think they're trying to find a way to get away with something, then supporting this process is likely the way to go, and likely will be protective both of the employee and of your own business. On the other hand, there are very specific strategies and techniques that can be used in order to determine the extent of an individual's psychological-based difficulties. And that involves formal examinations. Many of you may have been, many of you are aware of that type of process where you consult with an experienced mental health provider, and it doesn't have to be just psychology. But I have a declared bias. I think psychological testing and certain kinds of psychological testing can help clarify the clinical picture. I think there are certain types of testing procedures that can also speak to matters of authenticity and reliability and validity of a person's self-report. And that again will provide you with additional information that you could use to make a determination as to whether you continue to support this individual clinically or whether you have to do something else. But I do think that the role of a consultant, whether it be from your offices or from a mental health office, would be very important for you to pursue, particularly in terms of ensuring that everyone is given the best opportunity to recover and to make sure that your place of employment is seen as and has in fact maximized that level of recovery.
Great, and I think that sort of ties into, Ron, what you were saying about being able to get an assessment if required. I think that is the same practice, just to clarify.
Correct. I guess that the issue would be the timing of the assessment. You don't want to get that done too early, or it could may run into problems with the Human Rights Tribunal. So the timing of it is going to be key.
I agree. I think that not only is the timing key, but I think that because this is an evolutionary process, we need to give, unless there's good reason to doubt, we need to give every individual the possibility of recovering, and that does take time. It's when a person is not recovering in a way or in the manner that you would anticipate that one can start to ask some questions, but it's probably ill-advised to do this early on.
And I would agree with that 100%. So you want to give the employee the benefit of the doubt in these circumstances.
Yes.
Great. Okay, so we've addressed bringing employees back, but what happens in this situation, which probably is very likely, what happens if an employer needs to reduce its workforce? And what does an employer need to keep in mind when terminating the employment of employee? And Ron, I'm keeping an eye on the time, but I think this was a question that came up a lot in the submitted questions. So if you can spend a little bit of time explaining the termination process, basically.
Certainly. So Aneesha and participants, if the employee has not started, then the employer must provide a reasonable notice of the termination. Now, if the company has an employment agreement and a hiring letter, and it does limit notice to something under the common law, then that notice could be very minimal. However, if there is no employment agreement or hiring letter, or no termination clause inside, or it's poorly drafted, which frankly most that we see are, then the employer must provide common law notice. The common law notice can be very substantial, even for short-term employees. There was a rule of thumb of 1 month per year of service that no longer exists. But in certain cases, employees can get, even short service employees of a few months or a few years can get 6 months or more of notice. So it could be 1-2 months per year, or even greater. It levels out for longer term employees, but It could go to 24 months. There was a cap at 24 months a number of years back, no longer there. So it's even known to go beyond the 24 months. So if you need to reduce your workforce, the person has not returned to work yet, then you must provide reasonable notice. Now, there are some strategies. Do you have them return to work and then give them working notice? Because usually a great portion of the notice can be done by working notice. Now, if the employer waits until the employer returns to work, then the employer has to proceed with greater caution for fear that human rights issues could be raised. Because if the termination is done prior to the return, well, I think it's quite evident the return is likely because of the downturn in the economy. However, once they're back, the question is, then given that you have returned me to work, why have you now terminated me if I wasn't terminated prior to my coming back? Then you may need to have a reason, not necessarily that you need to rely on it when terminating, because one can terminate without cause, and we're talking about without cause terminations, where one does provide notice, but one should have some reason in case they're asked, and may have to justify that, no, it's not because of a human rights ground, it was truly a business ground. Many companies haven't felt the pinches yet, so to speak, and will begin to feel the pinch in next month and into the summer and into the fall and thereafter. So it's very key that when one does get good guidance through these situations, one doesn't want to get sued or a human rights application. These things are very expensive to defend, so if one can avoid that, all the better. Another thing, important thing to note is that the termination must be done privately, must be done respectfully. If one is terminating prior to the return to work, how is it done there? If one waits until the employee does return to work, how do you do it in that case? And there's different principles, and it already all depends on the nature of the workplace, what the employee's position is, and the circumstances. But in all cases, it must be done very respectfully and privately. Now, maybe Dr. Garber or Aneesha, don't hesitate to jump in on this, because I know with respect to how to gently ease someone or communicate to them that they have been terminated, that's difficult, because this could lead to loss of their home and other severe economic consequences. So maybe Dr. Garber, if you could help us with some just principles we want to keep in mind when communicating bad news to an employee, we'd appreciate that.
It's an interesting and challenging issue in the best of circumstances, let alone right now, especially when you understand that this type of termination is just an add-on sense of stressor that can likely further jeopardize the integrity and stability of the family system. Terminations take place within context of relationships. New employees, people that don't know you or you don't know them, likely have a different dynamic in play. If there are employees that you feel would be better off not working for your company, I think an open level of discourse and discussion is probably a useful opportunity to let them know the reality of the circumstance that you find yourself in. Again, being transparent and genuine as you can be, while at the same time giving them an opportunity to express their concerns. Questions around how it's done, and they've been out of the office for a number of months. Is it best to bring them in? Is it best to do it over the phone? Or maybe a combination of both, where you give them the choice. If they want to come in, you deliver the news in a gentle and empathic fashion, as empathic and as gently as one can deliver such news. I don't think anyone will be surprised at the fact that there's a substantive need to renegotiate and restructure. And I think it would be useful to be able to express those very real challenges, very real business challenges with which you as employers are confronted, and provide them with an opportunity to respond to that. No one is going to be, I don't think many, and I was going to say no one's going to be happy with being terminated, but I think the process of determination, in fact, will be reflective of the kind of dynamic and the kind of interpersonal connection that has been established during the course of their employment.
It's good. Thank you very much. Another key thing that we would suggest is utilize the services of an outplacement counselor. There are many excellent outplacement counselors, and often when the termination is done, the meeting is with the outplacement counselor who comes in right after the termination, and then that allows an avenue for the employee to focus on and help them. And they truly provide, very good assistance in finding reemployment, because many have been employed for perhaps a decade or decades, and they're not used to finding jobs. How do you find employment now? If I had to find a new job, I wouldn't know where to start right now. So hopefully my firm will keep me. So the key thing is utilizing these services. Yes, the employer would have to pay for these services, but we would strongly suggest that, especially given these times. And it's really showing that you're being thoughtful and kind and considerate in letting employees go.
If I can add one thing, I think, Ron, when you were speaking, it occurred to me, employers need to, in some fashion, recognize that this return to work is uniquely challenging, and they need to be able to have consultants available to them to help them think through and deal with the issues that will come out, both from a physical distancing perspective, a mental health perspective, and a legal perspective. And I don't think employers should be hesitant in terms of reaching out, because in my opinion, doing this in advance or in process will diminish the exposure that they will have to difficulties later on.
I would agree. We do represent a lot of law firms, and it's interesting to see what they're doing. I was on a call some time back with 27 law firms across the country, and so a lot of law firms essentially, and other businesses as well, they are communicating their status to the employees. And because no one wants to hear out of the blue, what, the company's not doing well, I'm terminated today, with no proper communication prior to that. And many businesses are reducing their remuneration of two employees. It could be 10% or less than 10%. Some are reducing their work by half and pay by half. But many are taking these steps, and also many have started these steps when this just first happened, and look to see where are we able to budget the company differently so we can still afford to operate. So I think the key thing is good communication, ongoing communication, and therefore if one does have to terminate, then the employee would likely expect it and wouldn't be a surprise. So I would agree 100% with that suggestion, Dr. Garber.
Okay, so I think on that note, we have finished our planned presentation time, and keeping an eye on the time, we want to be able to address the submitted questions. So I'll turn it over to there. Some of the questions apply to both. Some of the questions are a bit more targeted to either the mental health side or the employment law side. So hopefully it'll be a nice mixture. Ron, I guess since we've been talking about terminations, I'll try and keep it within the same theme. There were several questions about termination. So I've just been trying to go through and see what are some topics that you may not have addressed, or just some different things. So definitely people are expressing concern that they've laid off their employees and they don't know and don't believe they can bring them all back. Is there a difference in the process, Ron, between if an employee has been laid off already, or if they just recognize now that they're going to have to let go of some of their staff?
The processes are different. Now technically, the layoff provisions under the Employment Standards Act are only available to an employer if there is a written agreement that allows the employer to do that, or of the nature of the work is such that the work is perhaps seasonal, and there has never been work out of the season, or the employee is part of a collective agreement in a unionized setting. So technically, other than those circumstances, an employer cannot temporarily lay someone off. Now, that's the law today. We call it the pre-COVID law what will the post-COVID law be? Because a temporary layoff, if you're not allowed to do that with no authority, is considered a termination. And it really does trigger payment of notice to the employee. What will the laws be? We're not sure. Will the laws recognize that COVID has caused an economic downturn and many businesses are just a straw away from closure? I think they will. I think the courts will balance it. If it's an industry where the companies are doing extraordinarily well, then no sympathy there. But I think the courts will look at it on a case-by-case basis. So on the temporary layoff, you bring them back, you make sure you're within the time, you continue to pay. If you want to terminate prior to the return or the end of the temporary layoff period, then you can do that. You got to provide notice. If you return them to work, then and terminate them thereafter, then you need to provide notice as well. And notice can be lump sum, it can be working notice, or it can be salary continuance, or let's say wage continuance, or any combination of those two or three. And under the Employment Standards Act, certain payments have to be paid on a lump sum basis. So every situation is unique, every situation is different. The key thing is the strategy with the termination and whether one needs to have evidence in the employee's file that the reason was economics and not anything else, because at times one can improperly conclude that it was related to a protected ground when it wasn't. So it's very key to do the paperwork and keep evidence of what you've done and build your case. Hopefully you won't have to use your evidence, but if you do, at least then you have some level of protection.
Okay, thank you, Ron. And so now I'll just try and jump back and forth. So Dr. Garber, one of the questions was, can you recommend some easy exercises or techniques one can do to easily at their desk to help curb anxiety?
There are a slew of things that can be done, but I want to caution people to be attentive to the fact that they are employers and not therapists or treatment providers. And there needs to be a fine line between offering treatment in some fashion as opposed to encouraging that people who need that kind of intervention seek it out, unique to them. There are all types of things. If you Google relaxation techniques, there are all types of breathing strategies. There are cognitive behavioral strategies. But I think one needs to be cautious about formalizing it within context of any kind of a workplace.
Thank you. And so Ron, back to you. So this is about an employee refusing to return to work if they feel unsafe because of COVID. And the question is, if that is the case, what are the employer's options if they have done all they could do to accommodate?
The key is finding out from the employee, getting as much information as you can. If they've mentioned that they're not safe at the workplace, I guess the issue then is, has the employer done everything that they reasonably can to accommodate? Now, maybe they haven't. Maybe they need to go that extra step. Now, at times, perhaps they have, but the extra step is it's a very little intrusion on them, or not costly, that it's worthwhile going that extra step, even if one doesn't have to, in order to save many issues. The risk area is if the employer believes that they have done what's reasonable, they can't do anything more, and they think that they've complied with the Ontario Occupational Health and Safety Act. The employee still could be feeling anxiety to the point that's covered by the Human Rights Code. So, and without even saying it or informing the employer. So it's always best when assisting employers, which we do, to proceed in an abundance of caution, and go that extra step. Ask them to provide as many reasons as they can. Ask them for a medical note And then you're able to challenge the medical note. And you may not want to, perhaps at the very beginning, especially if you've really noticed no apparent signs of anxiety on their part. You may, just because you haven't doesn't mean they're not suffering it. But the beginning part, we would always suggest that employers be more generous, be more accommodating. Once one's been off for a longer period of time, and that period depends on the circumstances, the employer, the nature of the job. But once one has been off for a longer time, then they can begin challenging that medical note. But it's a matter of knowing what to ask the doctor, because certain things you're not supposed to. And that's a breach of the Human Rights Code if you ask too much, or if you ask, what is the diagnosis? You cannot do that. That's a no-no. So it's very important to ask the right questions, know what those questions are, get guidance on that, and in really planning or strategizing a return to work for that employee.
Aneesha, I'd like to add something to that, if I may.
Sure.
I think it's important to also understand that anxiety in and of itself doesn't have to be limiting or disabling. The type of anxiety that we all experience while present can be worked with. And while I do agree completely with Ron that one needs to be compassionate and sensitive and understanding and supportive, one also needs to recognize that if a person is describing concerns that are involving anxiety-based issues, there are established best practice processes that a person can try to facilitate a reduction in that anxiety, or manage that anxiety in a way that will allow them to try to come back to work. Anxiety, more often than not, does not take place in isolation. There are a slew of other signs and symptoms of clinical concern that would help us better understand the severity and gravity of that anxiety. So I do think that a combination of processes and procedures, including consultation with someone that can help you better understand that process, in addition to recognizing that legal issues are at play. Are you able to say to a person, yes, but if you see, let's try to see if we can help you get back to work. And fortunately, I don't take any responsibility for the legal implications of my clinical advice. That's not my job.
So here's an example of how Dr. Garber and I worked together. An employee has indicated that they feel anxious. They've mentioned other things. We need to draft a letter to the doctor to get more information if the medical note is really sparse. Dr. Garber would then be a good source for us to communicate with and discuss. Maybe there are signs that were present that the employer hasn't seen. And Dr. Garber can assist us with recognizing these signs, and also assist us in knowing what to ask the doctor, not the legalities of it as to what you can ask, what you can't ask, but information that would be helpful to obtain. And then once our client and we are aware of this, then we would then draft something that is very carefully done to make sure that the question or response requested would not be a breach of the Human Rights Code.
That's significant, not only in terms of a legal perspective, but from a clinical perspective. If we approach this from a worldview that we want to help people get back to where they want to be, assuming that there's genuineness and sincerity and there are no other things in operation, then clinical processes do exist that can help people get there. How people respond to those clinical processes become an important piece of information that always needs to go back to a lawyer in terms of the litigious nature of the industry that I work in. So the clinical reality of the circumstance always has to incorporate a legal opinion as to whether you can or can't enact that which is being suggested.
Now, Dr.
Okay.
Garber, you mentioned litigious nature, and I have noticed, actually we've discussed this as well, in the last week or two, we've seen different advertisements and essentially, some even encouraging employees to to battle with their employer. And this is not the attitude at this time. I think we need a team attitude. We need cooperation, and because I think the courts will recognize this. The employer, yes, has to be compassionate. The employee should be understanding as well, but it has to go hand in hand. And we think that, especially given these unprecedented times, the courts will acknowledge this, and the courts will consider the employer's efforts, what they've done, and also realize that the employee can't take advantage of the employer. But if they're truly going through issues relating to mental health, then clearly they're entitled to accommodation and help there. So it's really a blending of the two, and we hope that this sort of open communication with employers employees is fostered, and the more that's done, the less disputes there are going to be, the more understanding there'll be, and the quicker employees can get back to work, and the more longevity there'll be with that employer and with our economy.
Okay, so I'm just keeping an eye on the clock, and it looks like we maybe have time for one more question. There were, we received many questions, so obviously we unfortunately are not going to have time to deal with every single question in this presentation today, but we will get contact information from the City of Markham and reach out if your question hasn't been addressed in the presentation, because I think some were pretty closely aligned to what has already been discussed. So let's see, this is one that could be handled by both of you. So the question is, how do you handle employees who are being asked to return to the office but still don't feel safe to? As we've been working from home since March, and the current return to office is not a necessity, but more a want to return to normal. What is the best approach to take?
Go ahead, Rod. I'm waiting for you.
Okay, I'm waiting for you, Dr. Garber.
Okay, so whose want is it becomes the question. Who wants the person to return to the office? And again, every one of these circumstances needs to be contextualized in terms of the history that you have with this individual. I think for an employee that is valued and is recognized, and you have no concerns about issues of authenticity or legitimacy, then their concerns, their hesitancy needs to be better understood. They're being fearful for what reason? For themselves, for others. There's so many moving parts to this. Is it that they would prefer to stay at home because of other obligations? Is it because they don't want to risk exposing other members in their extended family? These are all very legitimate issues. And if possible, I think that the rule of thumb would be accommodate if you can and if you think it's reasonable. But I do think it would be important to have a discussion about what it means to them to be anxious about or fearful about returning to the office.
And Dr. Garber, I think as well, the key thing would be open communication. And that can be fostered now, before the return to work. And it may be that some workplaces, some workers are more efficiently run with the employees working from home. Other times they're not. But I think employers have to be open-minded to these different things, these different avenues. Communication is going to be the key. And I think if that's fostered and encouraged, then companies and workers will work out the perfect scenario that does work, be it working from home, be it back at the office. What I should also say, I should emphasize this, is we have a lot of great information we've received from Dr. Garber today and Aneesha, and we've had some excellent questions. As we speak, we have one of our lawyers who is listening to this as well, who is frantically writing down to make sure this information really is, a lot of the information is included in a return to work guide. And we think this will be very helpful. So please check our website. It may not be on today, maybe try later today or tomorrow or the next, but we're going to have it for you to help the employer with this whole return to work, employment law, and mental health issues?
I have a practical suggestion, if I can, and it follows from Ron's comment. I think it would be useful for those who are so inclined and are capable to reach out to your employees well before you are contemplating this return process, and to talk to them about the fact that there is a return process being planned. Hear what they say. Listen to their response. Be attentive to their hesitancies or ambivalences. The very fact that you show an interest in establishing that level of dialogue, I think will serve both you and them well.
Great, and I think that's a good way to end it off. So thank you again to everyone for joining us this morning. We believe this is a really important topic, and as mentioned earlier, it's really an ongoing discussion, and change is probably happening likely every week, and as we see, COVID and the return to work develop. So it's an ongoing process, but we think starting the conversation is important, and so that's why we're happy we were able to bring this webinar to you today. If you have any further questions, please don't hesitate to reach out. We'd be happy to discuss them with you. And with that, I would like to pass the floor back to Tiffany.
Great. Thank you, Aneesha. I hope everyone can hear me. So my name is Tiffany, and I'm with the City of Markham and the Markham Small Business Center. I just wanted to thank everyone for attending and spending your time to participate in this seminar this morning. The topic we know is very relevant. It's also a very important one. So again, a big thank you. And as Ron mentioned earlier, their guide, Returning to Work guide, will be on their website shortly. So check back tomorrow or the next day, and it'll be there. Their website is on the screen right now. You can see www.minkenemploymentlawyers.com. And another website I wanted to point you to is our Markham Small Business Center website. So that's msbc.markham.ca. Again, it's on the screen. You'll find there our calendar of events where you can see upcoming seminars just like this one. I think our next one coming up is a digital marketing topic. So it's a social media topic. So you can go ahead and just register online there.
Now, Tiffany, if I could just jump in there regarding the guides, where I would suggest it may not be up until next week.
Okay,
So
no
we
worries.
needed a few days. I'm just got a text message from our office saying that they've just been inundated with matters right now. So it could be next week, but we will definitely have it up for you, and we hope it's helpful as well.
Great, thanks, Ron. And also the recording of this seminar this morning will also have available on our Markham website. So that's the msbc.markham.ca website. And again, probably not today, but check back tomorrow, the next day, we'll have it ready for you. If you have any questions, like Aneesha said, you can contact the employment lawyers directly, and they're happy to help you out. If you have questions about small business, starting your business, or continuing your business, things like that, we can definitely, the Markham Small Business Center can assist you as well. And that's it. I think we're going to end up closing this event. And again, thank you to Minken Employment Lawyers. Thank you to Ron and Aneesha. Thank you to Dr. Joseph Garber. City of Markham is happy to host these events, and we are going to continue to bring you valuable and helpful information. Thank you to all the business owners online.